Welcome to today's webinar, Understanding Patents, which is part of our series Getting Started with IP. My name is Fasiha, and I work in CIPO's Business Services branch in the Intellectual Property Awareness and Education team. And today, we're going to cover the basics of patents, and hopefully by the end of this presentation, you'll have a clearer understanding of what patents are and how they work. Before we begin, you might be wondering what CIPO does. IP rights are territorial and are managed by the IP offices of countries around the world. In Canada, it's us, the Canadian Intellectual Property Office, or CIPO, that is responsible for the administration of most Canadian IP rights. CIPO is part of the Government Department for Innovation, Science and Economic Development Canada, and we handle application guidelines, forms, and examinations used in the process to issue patents, trademarks, and industrial designs. We also work on increasing IP awareness among Canadians. So as I mentioned, we work to raise awareness for the effective use of IP by Canadians. To this end, our IP Awareness and Education program delivers a wide range of products and services, free of charge, to help Canadians better understand the importance of protecting and managing their IP assets. We are a team of content writers, presenters, and IP advisors who can assist innovators, creators, and entrepreneurs in understanding IP before engaging in discussions where, inevitably, their IP will become a central point of the conversation. Therefore, we have the resources to explain what IP is, how to identify your IP, how to protect it, how to manage it, and perhaps most importantly, where to find help. Our tools and resources are available on our website, and we also offer fact sheets, detailed guides, online learning modules, and roadmaps to explain the steps needed to register for formal IP rights. We also organize seminars and webinars, and it's also possible to arrange meetings with our IP advisors either online or in person. So what we'll be discussing today is primarily based on the types of questions that we receive from innovators or entrepreneurs seeking to better understand patents. The first thing that they often ask is, what is a patent and what exactly does it protect? Should we consider getting a patent? How can we determine if a patent is suitable for their innovation, and how much does it cost? They might also ask, how long does it take to obtain a patent? And this is usually a crucial element to consider in the process. They also ask, who can help us? Because the role of the Canadian Intellectual Property Office, or CIPO, is more general. As a government agency, we receive your application, but we cannot provide specific advice like, you should claim this in your application, but not that. However, we can direct you to intellectual property professionals who can better assist you. And finally, once you have a better idea of what intellectual property is and a better understanding of patents, what are the next steps if you have an invention and want to obtain a patent? That is what we'll aim to answer today. So let's start with an overview of what intellectual property generally actually is. So IP is all around us. It's in the clothes that we wear, the coffee that we buy in the morning, the electronic devices that we use every day, and the music that we might listen to on the way to work. IP comes from a creation of the mind. It's actually the form an idea takes when created that can be protected. A few examples of IP include inventions, symbols, logos, pictures, designs, literary and artistic works, and many other representations. IP rights encourage innovation by giving creators the exclusive right to prevent others from stealing or appropriating their innovation, and we find that most businesses have some form of IP, whether it's formally protected or not. And in business, IP can set one's goods or services apart from others and is referred to as property because just like real property, rights are acquired with ownership. Like when you own a building or some land, you can sell it, lease it, and keep others from trespassing into your space. Same with IP. You can sell it, license it, or exclude others from using it. And also, like real property, IP is an incredibly valuable business asset. So here on the screen you see some traditional types of IP and the registered rights that are associated with them. Let's begin with patents, the main topic of this presentation. Patents are all about functionality. It's about providing technical solutions to a problem. It's all about the way that you can protect new or improved products, machines, processes, and compositions. In order to be patentable, the invention has to be new to the world, useful, meaning that it must work, and inventive. Then we also have copyright, which typically protects music and artistic creations, and it's all about original expression. It's about creations that use some level of judgment and skill and are not just a mere copy of another work. And then we have industrial design, which, on the other hand, concerns the appearance of an object. It serves to protect the unique aesthetic or the appearance of a product. It's all about what appeals to the eye, so that could be unique shapes, patterns on clothing, fashion accessories, technological devices, etc. And then we have plant breeders' rights, which protect varieties and denominations of new plants. However, CIPO does not manage the application process for this. It's actually the Canadian Food Inspection Agency that takes care of them. And lastly, we have trademarks, which refer to signs that distinguish one's products and services from those of others in the marketplace. So a trademark can be a word, symbol, design, taste, or even a sound, scent, texture, or more. It's all about what consumers often first see and how they navigate the marketplace. So it's really all about being distinctive so that consumers can easily identify a trademark and the associated product or service with it. Trademarks at large also include geographical indications and certification marks. So IP includes valuable information, and it's important to note that while that's true, there are other types of IP which hold valuable information but cannot be formally protected. So a good example of that is a trade secret. A trade secret is any business information that derives its value from its secrecy. It can be a method, a technique, any know-how, research, analysis, data, a customer list, a formula, you name it. It's just some sort of competitive edge, but one that cannot be formally protected. So trade secrets are incredibly valuable. However, they may not be the best choice of intellectual property protection if your competitors can easily reconstruct or reverse engineer your creation. Reverse engineering is when you can recreate a product just by looking at it or seeing how it functions. There are other examples of non-traditional IP as well, like domain names and websites, which, despite commonly being confused, are not the same as trademarks. And then, of course, we have social media accounts that contain a wealth of IP information, like trademarks, copyrights, and more. Now, let's focus on patents. So what exactly is a patent? Well, a patent is an exclusive right granted to the inventor to prevent others from making, selling, or using their invention for a period of 20 years. You can think of patents as an exchange with the government. You disclose your invention and get exclusive rights in exchange for sharing your knowledge with the world. So when someone submits a patent application, their application will be shared with the public, typically 18 months after submitting the application for registration. And once that's the case, anyone can access it. It's this concept that promotes the dissemination of knowledge to the public and stimulates innovation. The goal is that other people can learn about existing innovations and be inspired to develop new ideas, improvements, and so on. So it stimulates not only innovation, but also technical progress. So you apply for registration, and if your application is approved and the patent is granted, it constitutes a form of legal protection for your invention or discovery. Patents are also a way for inventors and companies to protect their R&D investments and generate income from their inventions. In fact, patents are actually everywhere. If you walk into your kitchen right now, you'll probably be able to identify a large number of innovations already patented or in the process of being patented. For example, you probably have lights in your kitchen. The electric light bulb that was patented by Thomas Edison in 1880 is a great example of that. Most kitchen utensils and cutlery are were patented in the 1900s. So of course, appliances such as toaster ovens, blenders, coffee makers, these are all examples of patented devices or technologies. So you get the idea, but we could do this exercise in every room of your house. It's really all about understanding that patents are everywhere. So now that you know what a patent is, let's take a look at the 3 basic requirements needed for an innovation to be considered for a patent. The first is novelty. So with this, we mean that your invention must be new. It must be the first of its kind in the world, not just in Canada. Your invention will be compared to anything that has already been publicly disclosed, not just existing patent documents. This means that the invention must not have been disclosed to the public in any way, even by you, whether through publications, sales, or public use, prior to the filing of the patent application. If you publicly disclose your invention before filing your application, it may be impossible to obtain a patent since your invention would no longer be considered new. So, on the other hand, you could benefit from Canada's 12-month grace period, which allows applicants to file an application after disclosing the invention, but even then, it's risky to rely on this exception because other countries don't offer similar grace periods. Then the second criteria is usefulness. This is the idea that it must be useful, and it must be functional and operational. So this means that the invention must not be a purely theoretical concept or a purely aesthetic creation. The invention must work on a practical level. So if something doesn't work, it doesn't really contribute to the progress of society. For example, it can't be a simple mathematical equation or theory. You don't have to create a perfect working solution from the outset, but there has to be what's called a sound prediction that allows you to foresee the usefulness of an invention without doing any extensive testing. So someone skilled in the field must be able to understand and predict why and how your invention will serve its purpose. And then the third criteria here is that it's not obvious. So the invention must not be obvious to a person competent in the field in question. It must demonstrate inventive ingenuity. This means that your invention must be something that a person with the relevant experience and technical knowledge would not have thought of immediately. Take a bicycle, for example. The elements that make it up, such as wheels, a chain, a derailleur, it may all seem very obvious, but combining them to create a stable moving vehicle requires a certain amount of ingenuity. On the other hand, if you simply combine an ordinary pencil with an eraser, it creates nothing new and would therefore not be considered inventive. And it's also important to note that before granting a patent, the Patent Office will carry out an extensive search to ensure that the invention meets these criteria. And then it's also important to note valid prediction, for which a concrete example might be in the field of new technologies. Suppose an inventor predicts that a new battery technology that they have developed will double the autonomy of electronic devices. For this prediction to be considered valid, the inventor would need to provide tangible evidence such as experimental data showing the battery's improved performance in lab tests. In addition, the investor must present clear and logical reasoning explaining how the specific features of the new technology led to the increased autonomy. And finally, patent applications must contain sufficient information for an expert in the field to assess the validity of the prediction and understand how to achieve the expected result. Now let's talk about what can be patented. Let's take flying cars as an example. So a flying car would have several elements that could be patented. Let's take a look first at the product itself. So this, of course, could be patented. The overall design and the structure of the flying car, including its functionality and unique features, are all patentable material. Then when we talk about the process, the operating process of the flying vehicle could as well be patented. The method of taking off and landing, the method of controlling and navigating the vehicle, and the method of converting between a car and an airplane could also be patented as a process. And then when we talk about the machine itself, any unique mechanical or machinery parts inside the flying vehicle, such as the engine, propellers, or the transmission systems, could all be patented as a machined object. And then we have the composition, so this refers to specific materials used to build the flying vehicle, including unique or innovative materials that, for example, could be so light that they allow the car to fly, are all materials that contribute to its performance or safety. These are all examples that could also be patented as a composition of matter. So patents can be a product, a process, a machine, a composition, or any improvements to any of these. An invention need not be revolutionary in order to be patented. In fact, around 90% of the patent applications are improvements to existing inventions. So don't necessarily be discouraged when consulting databases if the patents found resemble yours. We're talking here about prior art, which is what has already been patented. And since most patents are improvements, even if it's only a slight improvement, it may still be patentable. It's also important to note that patents are legally complex, and these items may or may not be eligible for patenting in a specific country, depending on existing laws, policies, and prior art. So there is a bit of comprehensive research that goes into answering that type of question. Now, with what we've just seen throughout the course of this presentation so far, is a patent the only way that you can protect an invention? This, of course, is false. So in many cases, there are other ways to protect your innovation. In fact, before you apply for a patent, you need to protect the information related to your invention. These are known as trade secrets and confidential data that are protected by non-disclosure agreements or confidentiality agreements. However, this is not the only way to protect your invention. So as we're talking about that kind of element of making that decision, let's take a deeper look at understanding if patenting is the right decision for you. So a patent can be useful, but it's not always the best solution. A patent is a big investment in terms of time and money, and most importantly, you'll have to accept that eventually your patent application will be disclosed and can be read by anyone since it'll be published in databases. So let's make a list of disadvantages to consider. Firstly, the cost. So obtaining a patent can be expensive, often involving legal fees, filing fees, maintenance costs, etc. And patent owners must pay these fees to keep the patent in force. And we'll get into a bit more detail about the costs later on during this presentation. The second con is that it is quite a long process. The patent process can take several years to complete, so is it even worth filing if your technology is going to continue to evolve? Then we have limited protection. So a patent may not provide full protection for the invention as it can be challenged or circumvented. And then, of course, we have the narrow scope. So a patent may cover only a specific application or form of expression of the invention, leaving room for others to develop many similar products. And then we can consider the limited market exclusivity that this means. So even with a patent, an invention may still face competition from similar products. And then, of course, the disclosure requirement, meaning that the inventor must fully disclose the invention in the patent application, and that might potentially reveal trade secrets. So as we've seen, patents are just one form of protection for an invention. So if your invention is really difficult to reproduce, or if it's a difficult process to confirm that it hasn't already been used by someone else, or if your invention is likely to be short-lived, then there are other alternatives to consider. For example, a trade secret. This is a great alternative to keep the invention confidential and not disclose it to the public. Secrecy protection, of course, is your responsibility, but much more difficult to put into practice than patent protection. You can also look at copyrights, which are another alternative to protect original works such as software, plans, and technical drawings. And then trademarks can protect the overall brand, the logo, the names associated with the invention. And then, of course, we have industrial design rights to protect the visual design of the invention. And then prior art is also the option of public disclosure of information about an invention, and which it can establish as prior art. So this strategy makes it difficult for others to obtain a patent on similar ideas. So each of these alternatives has its own set of advantages and limitations, and inventors may even potentially choose to use a combination of these methods to protect their invention. Ultimately, the right strategy will vary from situation to situation, and that's why it's important that you do your research, know your market, and develop the right IP strategy early on in the process. So again, I have a question for you now. How many years do you think it takes to get a patent? So the time it takes to obtain a patent can vary significantly depending on factors such as the complexity of the invention, the workload of the patent office, and the number of modifications or objections filed during the examination process. But on average, it can take from 2 to 5 years or more to receive a patent, after filing a patent application. So now that we have a better understanding of what a patent is, what it can protect, how long it might take to obtain, how much does it cost to get it and maintain a patent in Canada? So let's try to answer that question by looking at the fees in the table that you see on the screen. So here's a brief breakdown of the cost of obtaining a patent in Canada without legal representation. So first of all, fees will vary depending on the classification of the applicant entity as either a small or standard business. The small entity provisions encourage universities, small businesses, and individuals to use the patent system by reducing certain fees by about 50%. And you can submit a small entity declaration at the time of filing if you are, again, an individual or an entity that employs 50 people or fewer or are a university. There will be a one-time fee, such as a filing fee, an examination request fee, and final fee. And as you can see here, maintenance fees are due annually starting from the second year on the anniversary of filing, and they increase every 4 years. So if you are a small entity applying for a patent in Canada, you'll pay about $210.51 at filing, $408 at the examination request, and then for maintenance fees, it will vary based on the years. Year 2 to 4 will be $50, years 5 to 9 will be $100, and then so on. And then $153 for the final fees when the patent is granted. All of this coming to a total of $921.51, and then of course you can double that if you're a large entity. Obviously, there might also be legal fees if you choose to take that avenue. You may incur these fees by engaging a patent agent to help draft your application, to file it, to manage the application process with CIPO. So it's also important to note that only a very small fraction of applications are filed by inventors themselves, only around about 2%. And of those, it's safe to say that a little less than half, sometimes much less, result in granted patents. So it's definitely a good idea to seek assistance for this process. Again, there are possible additional fees, such as advanced examination fees, which must be paid whenever the applicant wishes to expedite the examination of their application. And as for late and reinstatement fees, these are due only when the applicant misses a deadline. For example, the applicant might be late in paying fees or responding to an office letter, etc. Fees may also vary for applications where the patent has been the subject of an international search by the commissioner. And for further details on that, you can find more information on our website. So overall, it's important to note that the costs associated with obtaining a patent can add up quite quickly, so it's incredibly advisable to budget accordingly and gain a clear understanding of the expected costs before commencing with the process. And so, of course, we've spoken at length about the complexity of this process. So why should you be looking for an intellectual property professional? What is the benefit? So a patent agent or an IP attorney can assist an individual or a company in the process of filing a patent application by providing the following services. First of all, they can provide a patentability search and analysis. So this involves a comprehensive search of existing patents and published patent applications to determine if the invention is new, non-obvious, and worthy of pursuing a patent application. Second of all, they can help with the preparation of the patent application itself. So this means drafting a detailed and comprehensive patent application that includes a clear and concise description of the invention and all of its unique features. And then, of course, we can also gain their insight on prosecution of the patent application. So representation before the patent office during the application filing, engaging in discussions with the examiner, responding to office actions, and handling objections raised by the patent office during the prosecution process. And then lastly, they can help with the overall maintenance of the patent. They can do this by ensuring the validity of the patent once it has been granted and providing assistance in enforcing your patent rights if necessary. The costs associated with these services can again vary significantly depending on factors such as the complexity of the services provided and the agent's expertise. However, for a patent in a single country, the cost of these services can range from about $5,000 to $25,000. Additionally, it's important to remember that CIPO will only communicate with a patent agent registered with the College of Patent Agents and Trademark Agents, or CIPATA. This means that CIPO will not correspond with an individual claiming to be a patent agent unless they have met the college's requirements and are currently listed as a registered patent agent. This measure also helps us avoid imposters, which unfortunately are quite common in the IP community. So you can currently check this list on the CIPO A&E website to look for IP professionals and just learn more about what they do. So another true or false question for you to consider. Once I have obtained a patent from CIPO, my invention is protected worldwide. Is that true or false? Of course, this is false. A Canadian patent is exactly that. It's a Canadian patent. It does not provide protection outside of Canada. To protect your invention in multiple countries, you need to file separate patent applications in each country where you can seek protection. Also, the process of obtaining a patent in multiple countries can be complex and expensive, and it might actually be necessary to engage with the services of a patent agent or an attorney specializing in international patent law. Canada is also a signatory to several international agreements that facilitate filing for protection abroad, such as the Patent Cooperation Treaty or the PCT. Again, let's consider this. Today, the laws, regulations, and practices in intellectual property are the same everywhere. Do you think this is true or false? Of course, this is false. Intellectual property laws and regulations are not the same everywhere. IP laws vary from country to country, and the process of obtaining a patent in one country may not be the same as the process in another. Additionally, not all countries recognize the same types of inventions for patent protection, and some countries have major restrictions on the types of inventions that actually can be patented in those respective jurisdictions. So, with all of this in mind, when is an intellectual property professional absolutely necessary? So even though you can file a patent application by yourself, it's important to consider the advantages of working with an IP professional. Engaging with an IP professional helps you save time and money, as they have the experience and knowledge to navigate the complex patent process and ensure that it's all done correctly. However, there are instances where the representation of a patent agent is an absolute requirement. So let's take a look at some of these situations where the inventor has no choice but to appoint a patent agent on their file. First of all, it's if the owner of the patent application is a company or an organization, then they need an IP professional's representation. Or second, if the applicant is not the inventor. Or third, if there has already been a transfer of ownership of the patent. So in these three scenarios, it is a requirement to obtain the services of a patent agent. Now, we're going to change the subject a little bit and talk about some very important points when it comes to the patenting process. We're going to talk about two specific cases which arise as issues within this process and can even be issues for the best of inventions. So first, it's revealing too much about your invention before filing for protection, and second, not researching what has already been invented. So both of these can have devastating consequences for a patent application, and I'll explain why. So it's tempting to share your invention with the world, especially when you feel that you have a worthy product that could revolutionize the market. Whether it's to assess the invention's profitability with potential investors or to post the idea on social media to generate early interest, inventors must be cautious about the premature disclosure of their inventions. The disclosure of an invention before filing a patent application in Canada can have several disadvantages. Disclosing an invention can lead to a loss of novelty, which of course, as we've discussed, is a requirement for obtaining a patent. If an invention is made public before filing a patent application, it can no longer be considered new and non-obvious, and consequently, it may not be eligible for a patent. And then, of course, we have the loss of confidentiality. So disclosing an invention can result in this because the disclosed information can be used by others to develop similar or competing products, which can ultimately undermine the potential commercial value of the invention that was the original one. And then, of course, the loss of first-to-file rights. In Canada, the first person to file a patent application for an invention has the right to obtain a patent, even if somebody else has already disclosed the invention. So if an invention is disclosed before filing a patent application, the inventor may miss their chance and lose their first to file rights, as someone else might file before them. So overall, it's generally advisable to keep an invention confidential and file a patent application before disclosing the invention to the public. This just helps maintain the invention's confidentiality and increases the chances of obtaining a valid patent. Of course, as we briefly mentioned before, some countries provide a grace period. So a grace period is a period during which an inventor can make a public disclosure of their invention and still be eligible to obtain a patent. In Canada, this period is about 12 months from the date of the first public disclosure of the invention. And it means that if an inventor makes a public disclosure of their invention within 12 months following the patent application's filing, the public disclosure will not be considered prior art and will not prevent the inventor from obtaining a patent. However, it's important to note that the grace period is not applicable in all countries, and in some countries, any public disclosure of an invention before filing a patent application can immediately prevent the inventor from obtaining a patent. So again, let's consider this statement. If my invention is granted patent protection, I can commercialize it without worrying about infringing upon other patents. Do you think this is true or false? Of course it's false. Let's see why that's the case. So this is probably one of the biggest and most common myths about patents. Let's talk about the freedom to operate. While a patent gives you the right to prevent others from making, importing, selling, or using your invention for a period of 20 years, in reality, this protection does not directly address your ability to market the patented invention. It might actually surprise you, but obtaining a patent does not necessarily mean that its commercialization won't be limited by prior patents. This is what we call the freedom to operate. It differs from the concept of novelty, which means that you have invented something new in the world. Freedom to operate concerns the commercial feasibility or the assurance of introducing your product into a given market of a country without infringing upon another person's valid patent rights. To illustrate this difference, imagine this. You are the first person to invent a flying car. You file a patent application and it meets all the patentability requirements, including the novelty criterion, so you're granted a patent for your flying car invention. The issue is that there might be someone who already has a patent that covers all cars, so your flying car would fall within the scope of protection of their patent. Therefore, as long as their patent is valid, you won't be able to market your flying car even though you had a granted patent. So a related question to this that we often receive is, should I wait for my patent to be granted before introducing it to the market? And to this we can say absolutely not. There are many products in the market that don't have a patent and many patents that actually don't have a market. But let's say that you have a patent that depends on other patents, then make sure that you have secured the rights to use those patents before entering the market. The most important thing is to understand that research should be conducted to comprehend the surrounding patent landscape. So now let's talk about prior art, or what has already been invented. We've already seen this refers to all information that has been made publicly available before the filing date of a patent application, and it includes all types of information such as patents, published patent applications, scientific and technical articles, books, or any other publicly available information. So we've seen why conducting a prior art search is important before filing a patent application. It's because it helps determine if the invention is novel and non-obvious, as we've seen are requirements to obtain a patent. But if prior art exists that is similar to the invention, it may be considered not new or obvious, and a patent may not be granted. So you can conduct a preliminary search for prior art on many different databases. The first is the Canadian Patent Database. Then there's also Patent Scope, which is the foreign database of the World Intellectual Property Organization, or WIPO. Searching the Canadian patent database is free and is usually done by a keyword search or patent classification. There's also a help tab there that provides assistance to help novice users successfully navigate the database. However, CIPO strongly recommends seeking the assistance of a patent agent or a patent lawyer for that preliminary search. When reviewing the search results, you'll need to compare and contrast your invention with others and weigh their similarities and differences, and this is usually quite an extensive exercise that often requires the judgment of an expert. In summary, today we've reviewed the patentability criteria, the costs associated with it, the timeline that is involved, as well as alternatives to a patent such as discussing trade secrets. So the next step is to learn about preparing a patent application. And of course, for this, questions might arise such as, where should I file worldwide? Should I engage with an agent? To continue your learning about this, we do offer additional webinars that will delve a bit more into detail on these more intermediate patent topics, including how to read a patent, patent claims, what is protected, what to include or exclude, the patent prosecution process, including the filing date and the examination request, and then of course filing abroad, the PCT, the dates, costs, and many other considerations that go along with it. So all of the resources, materials, and tools that I've talked about contain a wealth of useful IP-related content, and they're available on our website in many different formats such as audio, video, text, and interactive. And we are extremely happy to guide you and give you as much information as possible on IP rights, but unfortunately we cannot provide you with legal advice, and sadly, this is the case that all of these questions that appear on the screen are extremely common questions, but unfortunately, there are questions that all require a legal opinion. And you might also find that throughout the course of this process, you need help in understanding more complex topics or obtaining legal advice in case of infringement, or seeking an opinion on strategic positioning and searching advanced databases. So to all of this effect, there are groups and associations of IP professionals that you could turn to. First of all, as mentioned earlier, to locate a licensed IP agent near you, you can contact the College of Patent and Trademark Agents, or CIPO A&E, which is the newly formed organization responsible for the management of IP agents. And we recommend that you only deal with IP agents that are on the CIPO A&E list of registered IP agents. These are individuals that have passed IP-related exams, they're regulated and disciplined by the CIPO A&E, so there's an added layer of reassurance. Unfortunately, there are individuals out there who will try and pose as IP experts despite not having the required credentials. So ultimately, it's your responsibility, and it's an extremely important consideration to stay diligent and consult the CIPO A&E website to ensure that you know who you're hiring to assist you with your IP rights. And then, of course, the Intellectual Property Institute of Canada, or IPIC, and the Bar Association are two other professional associations where you can find the services of a lawyer or IP professionals. So please don't hesitate to contact us if you have any questions or need help finding any of the resources on our website. You can reach us via the contact information that you are able to see on the screen. As well, you can contact our intellectual property advisors for a more specific and tailored discussion to your needs by scanning the QR code that you see. And then for any general inquiries or questions about IP, you can reach out to our Customer Services Center by phone or email. The toll-free number is also provided on the screen for their services. And then, of course, I invite you to follow us on all of our social media, and I recommend exploring the CIPO newsletter titled IP for Business News, where you can find more information about new IP products, seminars, webinars, upcoming events, updates to the CIPO website, and more. So this concludes the webinar on the basics of patents. I hope you've learned more today and that you've enjoyed this presentation. To further explore the other topics related to intellectual property that were mentioned throughout this video, I invite you to watch our other videos and register for our live webinars on our website. And ultimately, I just thank you all for watching and have a great day.